So at this time, I'd like to introduce our guest presenter. Valerie Slater is a juvenile justice attorney who leads the Rise for Youth organization and advocates for the rights of youth involved in the many Virginia systems. Valerie has also worked to protect the rights of children with disabilities in community, residential, and juvenile justice facilities throughout the Commonwealth. She earned her undergraduate degree at the Colorado State University and her Juris Doctorate, a doctor from the University of Richmond School of Law. Valerie has dedicated her life work to advocacy in its many forms to preserve and protect our most valuable resource, our youth. And at this time, I will turn it over to Attorney Slater.
Thank you so much, Tina and Heidi, for having me this evening. And I'm excited to have this conversation about the manifestation determination review process with you all this evening and tomorrow evening. Looking forward to that as well. Tonight, we're going to be talking about understanding that process. And our agenda for the evening is, what is a manifestation determination review? What is it? And why do we conduct this review? And what is the process? And then we want to go deeper into each of the steps of that process. And then we're going to talk about the potential outcomes. And there are special considerations for the outcome and even for the administration of that process. And then in conclusion, we'll just kind of run through all of those steps again. And before we get started, I just want to share with you that I am currently the director of Rise for Youth, and Rise stands for Reinvest in Supportive Environments. And it's because we believe that every environment that touches a young person's life, a child's life, it ought to be creating the opportunity for that child to develop, to be healthy, to grow, and to thrive. And previously, I was a youth attorney at the Disability Law Center of Virginia. And so I'm excited to be able to go back to my roots of my work as an attorney and share this information with you all this evening and tomorrow. Now, let's jump in. What is a manifestation determination review? Also known as the MDR, as Tina previously mentioned. So, the definition is it's a review process to determine the educational placement for a student with a known or suspected disability, but who is now subject to disciplinary action. And this action would result in a cumulative disciplinary removal, meaning that a child is going to be out of school for more than 10 days. And that's out of their current placement. Now, this process, it applies to students who are served both through the Individuals with Disabilities Education Act, or they have an IEP, or Section 504 of the Rehabilitation Act, or they have that 504 plan. So it doesn't matter if a student is receiving special services, whether through an IEP or a 504 plan. If a student is suspected of having a disability, then this manifestation determination review process must be conducted. Now, the manifestation determination review process, it was first introduced with the 1997 amendments to IDEA. So why is it that we would conduct an MDR? It's basically so a school cannot change a student's educational placement or remove them from school for behavior that stems from their disability. And that was secured through Honing v. Department of Education in 1988. So the purpose of an MDR, it's also that a local education agency, the parent, and every relevant member of a student's IEP team, to include the student, right? To include the student. They come together to conduct a review that is going to determine if the behavior that is the subject of this disciplinary action, if indeed it is a manifestation of that student's disability. So what is the MDR process? Let's walk that through. So it begins with the behavior. There's some behavior that has occurred, which is the subject of this potential long-term or more than 10-day disciplinary change of placement. Then the parents have to be notified, and that notice has got to include that, that they are going to, that a school division is considering a long-term or a more than 10-day removal, and that there is now triggered the need for this manifestation determination review. And it must also include the procedural safeguards that a parent has. Now, then, once that notice has been given and that MDR has been scheduled, then the parent and all of those relevant members of the team, they're going to come together and review information to determine if indeed the behavior is a manifestation of the child's disability. And then if that behavior is determined to be or not to be, there is going to be some sort of action. Action is going to be required. And without getting into it, I keep wanting to jump ahead, but right now we're just walking through the process. Then there is going to be either placement being maintained or placement is going to change. And that is all going to be determined by whether or not this is a manifestation of a child's disability. But there are special considerations. We'll get into that later. Now, parents have a right to appeal the decision of a manifestation determination review, right? They have the right to say, I don't think you got it right. And so we'll walk through what that looks like. And then there is a stay put provision. So let's say that parent decides they are indeed going to challenge the outcome of that MDR. Then that child is able to remain in their current placement and until all procedural challenges have been exhausted. And then there will be a final placement determination. So that's the process. And it seems arduous, and it is. There is no short, easy, easy peasy, quick to the finish line. No, oftentimes it takes a bit of time, but you've got to be willing, you've got to be ready to play the long game to make sure that your child gets their free and appropriate public education, that it is provided to them without interruption and in the least restrictive environment, whatever that environment might be. So we are going to start with, I need to move this, the toolbar is in my way. So when disciplinary action is considered a change of placement, when is it? So a disciplinary change of placement occurs when a student who's receiving special education services is excluded from school for more than 10 days in a row, or for a pattern of exclusions that equal more than 10 days. So a series of removals that total more than 10 days, it can look like the student's behavior that has caused a 1-day removal or then a 3-day removal. It's always that same behavior or similar behavior that's driving that removal. Or it's the student is removed for 2 days here, 5 days there, 7 days there. And again, it's all substantially the same behaviors. So all of those removals will then be aggregated to say, hey, there is a behavior that is causing you to take this child out of school for more than 10 days, and that is triggering that MDR process. Something really important to note here is that if indeed there is a pattern of behaviors, then it may be the parent who would raise that flag to say, hey, you've suspended my child for this very behavior several times before. And at this point, we're hitting that 11th, that 12th, that 13th day. Or if my child were to spend all 3 of these days out of school, we will cross over that threshold. And again, that will trigger the manifestation determination process. Let's see. So what about a student who isn't eligible yet, a student who has not been found eligible for special education services? Is there an instance where even a student who has not been found eligible, who is not under an IEP or a 504, that they would receive those services or the MDR for their behaviors? The answer is absolutely yes. So if a student has, if the school has been made aware by the parent that they are suspecting that their child has a disability, if the school has been made aware because the parent has asked for their child to be evaluated, if the school is on notice because that child's teacher, one of that child's teachers, has repeatedly asked for support because of this child's behavior, and it is indeed impeding this child's ability to access education, then the MDR process will be triggered for that child as well, even though they have not yet been found eligible for special education services. Now, I've already kind of walked through these acknowledgments here, but the school has knowledge, again, if the parent has expressed concern in writing. Now, here in Virginia, it doesn't have to be in writing, but I'm saying put it in writing because anything that's not in writing can potentially not exist, right? What if there is staff overturn and whoever you notified is no longer there? The school, of course, would then say, we did not know. Or unfortunately, there are also instances when the school division just may not have documented what you may have said. And so then again, if there's no documentation, it's really hard to prove that you have put the school on notice. And so in writing, notify the teacher, notify the principal, notify someone in the administration, the school counselor, the school nurse, notify someone that you are concerned about your child's ability to access learning, whether it be for their behavior or whether it be because there is some sort of a learning need that needs to be addressed. Nevertheless, put it in writing and let them know. Now, also, if you have requested an evaluation, the school is on notice. And then thirdly, it's the teacher or someone else in the local educational agency that has requested some sort of supports for the student. And now they cannot forego this manifestation determination review because they are indeed on notice. Now, so once again, when a student with disability is about to be suspended or they're considering a long-term suspension, they've got to send written notice that that long-term removal may or will be contemplated. And they've got to include a copy of procedural safeguards. Notice must be given not later than the date of the decision to suspend that may trigger a long-term removal. So that means you're ready to suspend my child. You're going to send a note home letting me know that there needs to be a manifestation determination review. You can't wait until 5 days into the suspension to then notify me. It's got to be right at the beginning. Now, notice of the IEP team meeting that they will indeed conduct an MDR. So that means the teachers got to be notified, the psychologist, the school psychologist, perhaps the school counselor, and all other relevant personnel who should attend that IEP meeting. That notice to you, the parent, it must include all of that information, and that notice must also be given to those other key participants. Now, who should attend that manifestation determination review? There are some required, and then there are some recommended. So there must be a representative from the local education agency, the school, right? And it must be someone from the administration or from the special education department. You, the parent, you're a required participant. And often I have heard it said that, well, if the parent can't make it, we'll move forward. You can't adequately evaluate whether or not a child's behavior is a true manifestation of their disability without the person that knows that child best, that is the parent, being present. Now, relevant members of the IEP team should also be there. Again, the school administrator, the special education teacher. If the student is attending general education classes, if there is any pullout for any reason, whoever is conducting those educational services or whatever services are being provided, those individuals should also attend. If there is indeed a general education teacher, a general ed teacher should also be there. And then individuals who can interpret the instructional implications of the evaluation results, right? Someone who is able to look at all of the evaluations that have happened to and for this child, and they are able to interpret those results and make them relevant to this meeting. Those individuals must also be there. Now, who is recommended? It would be wonderful to have a board certified behavioral analyst. And it would be really important and helpful to have that individual in the meeting, because they are going to be able to speak to the behaviors, speak to what alternative behaviors to help to mitigate those behaviors, and what triggers those behaviors. And looking at the evaluations that have happened, how those, what the data says, and how that data then interprets into how this child is acting in school. Again, the school psychologists, individuals who have specialized knowledge or expertise regarding this child. Now, you, the parent, you absolutely have specialized knowledge about your child. But if your child is seeing a therapist not related to the school, that's someone with specialized knowledge and expertise regarding your child. Does your child attend other events, or are they a part of other groups? And in those other groups, do they provide special services to ensure your child is able to participate unhindered? And if the answer is yes, then that is another individual. The leaders of those specialized groups, they are other individuals who might want to attend. Is your child a part of Little League? Is your child a part of a painting class or other extracurricular activities where accommodations have to be put into place to allow them to access fully that new and different learning environment apart from school? Those are all individuals with specialized knowledge about your child. And then translators, if they're necessary, an advocate or parent's attorney, and anyone else that you as the parent deem appropriate. The school is going to bring everyone that they believe is appropriate, and you need to understand, as a parent, as a guardian, you have that same right. So exercise it. You make sure that you are there with everyone that is going to be able to shed light and help make a very informed manifestation determination as to what the appropriate placement for your child will be. Now, what are the questions that we ought to be asking during an MDR hearing? We're going to be asking, first of all, what is the eligibility for the student? What is the category under which they have been identified to receive these specialized services? And because that is probably going to lend itself very heavily to, in some instances, that's going to lend heavily as to whether it is a manifestation of a particular of that disability, right? And then, has the student's behavior resulted in a removal of 10 consecutive school days, or has it been a pattern? Has prior behavior caused the student to accrue more than those 10 non-consecutive days? And does the student have a behavioral intervention plan? Now, we'll get into that much more tomorrow, what the functional behavioral assessment and the behavioral intervention plan that comes from it. We'll get into that tomorrow, but it's important to ask these questions during that process, right? When you're preparing for the process, these are all of the questions that you're going to want to be able to answer when you're sitting down at that table. So, where is all of the information going to come from that MDR team is going to consider? It's going to come from teachers and parents, right? There's going to be the school record there's going to be all of the behavioral instances for a particular child. There are going to be the instances of what's going on in the home. When has a particular behavior manifested at home, and what has been the precursor to it? Is it something that you were able to predict because these set of circumstances happened and my child reacts in this way when those circumstances align? And is there evidence of the behavior under similar, right? And under similar circumstances. Now, also, we're going to be looking at the IEP or that 504 plan. So what are the goals? And are there any goals that specifically speak to behavior? And have they been implemented appropriately? We'll get into that tomorrow more as well. Then we're also going to be asking both the teacher and the student, what happened before? What was going on with the student even before they entered this particular classroom? Right? And so, yes, we're going to ask the teacher, or yes, we're going to ask the student, but then we're going to draw the parents into that conversation as well. Because if the student is saying, well, when I got to school today, I really wasn't feeling my best, then we're going to be asking the parent, are there any new health or medication information that needs to be added to what we already know about the child and that may have been a precursor to this particular behavior that is at issue here. And then we'll also be asking both the parent and the teacher, are there recent changes in the family? Are there recent changes in the classroom? Are there new expectations? What could be negatively impacting the student's behavior? And then finally, the student, what was your emotional status? And even, do you really understand this behavior that you have exhibited and the consequences of that behavior on your peers and on the school environment? All of those are going to be the pieces of data that we will need to collect and review thoroughly. I'm going to tell you what, there is nothing better than having your own copy of your student's file. You should have every evaluation that your child has ever undergone. You should have a complete discipline history for your child, behavior history for your child. You should have your copy of every notice that you have sent to the school requesting whether it be evaluations, requesting specific accommodations, requesting conversations with teachers, whatever it is that you have done to make the school aware of the needs of your child, you have copies of those in your own file. You also need to have copies of every IEP, every update to that IEP, those prior written notices, have a copy of every one of them, because those prior written notices are going to discuss, what changes have been agreed to and what changes have been rejected. And it should also have the why. And yes, it should be in the IEP. But if you have a copy of a prior written notice and they didn't, for whatever reason, it didn't make it into the IEP, you'll be able to pull out that prior written notice and say, well, on this date, we discussed this thing and we decided this and we rejected this. And even though I voiced my concern that if we didn't put this into place, X, Y, and Z would happen, now we find ourselves here in this predicament. All of that is going to be pertinent information. You want it, you need it. Make sure you have a complete file of your own, of your complete student record. Okay. I like to harp on that because, so often it feels like we're being bombarded with so much paper. You just constantly, oh my gosh, they're giving me this again. The only thing I would say you can, leave in a stack somewhere is those copies of the procedural safeguards. Unless they make a change in them, you're just getting that same book over and over again. But everything that is unique and specific to your child, have your own personal copy of it. So, what are the questions that must be answered during the manifestation determination review? So, was the behavior caused by or substantially related to the student's disability? Or was the behavior the direct result of the school division's failure to appropriately implement the student's IEP? Understand that a failure to implement a student's IEP could also mean you have brought to the attention of the school division an issue that needs to be addressed, and they have chosen not to address it, right? That again, let's get back to those prior written notices. Let's say your student's IEP addresses several things, but it leaves out, you have said, hey, I have begun to notice a particular behavior, and now I have heard from the teacher that this particular behavior is manifesting. And at home, when this happens, I offer my student a redirection, and I'm able to avoid a meltdown, right? Or I'm able to avoid more significant behaviors by offering this redirection, or any other example. And yet you bring it to the school, and the school says, well, no, the teacher has let us know that it doesn't seem to be raising to the degree that we need to add anything separate or different to the IEP. You make sure that you get that in writing in a prior written notice, because then all of a sudden you're putting the school on notice, and then failing to act becomes the school's failure to implement appropriately that student's IEP. So let's first talk about, was the behavior caused by or directly or substantially related to the student's disability? Now, we've got to determine whether there was a significant ability that may result in impaired judgment or reasoning. So does this student have some sort of processing or any other cognitive challenges that results in impaired reasoning? And then also determining whether that impaired reasoning has a direct relationship to that student's behavior. And so when a student has any sort of functioning or cognitive functioning impairment, and there is an MDR, we've got to make sure that, okay, whatever that impairment is, does it also then impair their ability to behave in such a way, or does it cause a behavior that would be disruptive to the learning environment? And then again, the neurological impairment, is there a history of voluntary control of the behavior in question? That's going to be a big one, right? And then not just voluntary control of the behavior in question, but are there, again, parent, you know best, are there precursors? Are there things that can happen prior to that behavior manifesting that can make it more difficult for that child to control that behavior voluntarily? Right? It isn't just whether, well, Johnny didn't do that yesterday. Well, he, acted like this yesterday, and as soon as I said, don't do that, Johnny, he stopped. Well, what was, again, that precursor? Were there such stressors happening in this particular instance that just made it impossible for Johnny to voluntarily control that behavior in question? And you, parent, you're going to be the one that understands that much more likely than anyone else in that IEP or in that MDR hearing. And then, was the student in an escalated state? Can that student even recall what was going on? Do they have knowledge to produce the ability? Can they perform that skill, whatever it is that you're saying, this is what Johnny should do instead? Are they in such an escalated state that they're unable to even access that space where you're saying, well, once before, Johnny was able to not do this by self-regulation? Now, going back again to, is it a direct result of the school's failure to implement the IEP? Was the student receiving reasonable benefit from their program? I have had many a client that has looked at what is being provided for their student and challenges whether or not it is appropriately meeting the needs of their students, both in the education space, but also in the behavioral space. But if a student isn't challenged appropriately in the education space, it may lead to behaviors. So if a student's behaviors, or if their needs are not being addressed appropriately through the IEP, like I said, you have raised these issues, they've done nothing about them, then again, they are not appropriately addressing the needs, and therefore it would be a failure of the school to appropriately implement the IEP. So, and then if you, after you have been reviewing your student's IEP, and you have been reviewing if there are any behavioral supports put into place, if they are not consistently applied, if they are not using these, if they are not providing access to these behavioral supports to the student, then that too would indicate it's the school's failure to appropriately implement the IEP. And so making sure that every necessary resource is available as a part of your student's individualized education program is going to be absolutely key. And documenting when the school has refused is absolutely key as well. So what are the potential outcomes of a manifestation determination review? So we know what the questions are, right? Is there a failure of the school to appropriately implement the IEP? Or is it a manifestation of this student's disability? Or is it substantially related to? If either of those questions are answered with a yes, then it is indeed a manifestation. But if the answer to both questions is no, then it is not going to be determined a manifestation, and that student is able to be disciplined in the same manner as a student without a disability who has violated that same or a similar code of conduct. So the school is never let off the hook for providing educational services to a student with an IEP or a student with a 504 plan. So while the student may, they may go to an alternative school, their IEP, their 504 plan is going to follow them there. If the school is placed on homebound, administrative homebound, that IEP, those, the 504, all of those services are going to follow that child home. Now, the number of hours that a school division is required to provide those services, that is going to be significantly reduced. Nevertheless, they have to provide the services as outlined in the IEP. So again, what if the behavior is a manifestation? Then if there is a BIP in place, it's got to be reevaluated for effectiveness. But if there is not, then the school has got to conduct that functional behavioral assessment and then develop a behavioral intervention plan. And no further disciplinary action can be taken. There are some exceptions. We'll talk about them in a little bit. Now, what if the behavior is determined not to be a manifestation? Then the school, again, is going to proceed with disciplinary action. The school may short-term remove a student with a disability from their education placement and provide services in the manner consistent with those provided to a student without disability. And let's see, if there are multiple short-term removals that do not form a pattern. So they're not on the hook for the whole gambit if it's short-term removal and it is not a pattern. But if indeed it is, if there is a long-term removal, then they are going to have to provide those services. So we just talked about those, I keep mentioning these special circumstances. So what are they? There are three. A school personnel, they can remove a student to an interim alternative education setting for not more than 45 days. If a student carries a weapon or possesses a weapon at school or on school premises at school functions, if a student knowingly possesses or uses illegal drugs or sells or solicits the sale of a controlled substance. Illegal drugs, we know what those are, but a controlled substance, those are the prescription drugs. And it's and now a student is attempting to sell or soliciting the sale of controlled drugs. Or if a student has inflicted serious bodily injury. So let's talk about once again, the big three: weapons, drugs, serious bodily injury. Now, even in those instances, the MDR is still required. It's simply that the student can be removed to an interim placement without regard to whether that behavior is a determination or is a manifestation of their disability. That 45 days is to preserve the safety of the school and the school environment and the students themselves. So now, let's talk about weapons first. It's a device, an instrument, material, or substance, animate or inanimate, that could be used for, is readily capable of causing death or serious bodily injury, except that such terms do not include a pocket knife with a blade of less than 2.5 inches. Now, I chose to use the U.S. code on these because oftentimes we run it. So I don't know if you've ever heard of those cases when students have brought toy guns or different things to school that are not, while it is a gun, it's a water gun. It's got that red tip on it, and it's very obviously not able to do it's not able to cause death or impose serious bodily injury. And so those zero tolerance laws have required that this level of definition be put forward so that we can hold schools accountable to providing education and not attempting to put students out for things that are not true weapons. Now, we talked about it a little bit, but there's the controlled substance. So it's anything that's on the schedule 1, 2, 3, 4, 5, or 5, right? Section 202 of the Controlled Substance Act. And then again, illegal drugs, that's also defined. I'm not going to go through it, but we know what those are. And so it's students who would bring, if your student brought any of these, if they brought illegal drugs to school, then that the school has the right for a 45-day removal. If it's controlled substance, then it has to be that they were selling or attempting to sell. So it's not just because that controlled substance is there. There are further hurdles that must be, the school has got to meet a higher standard. You can't just say, well, Johnny had this particular pill. Johnny had to attempt to sell that pill, had to be selling or attempting to sell those pills. So serious bodily injury. Now, again, I've chosen to use those federal definitions because we need to know, what do you mean serious bodily injury? It means injury that involves a substantial risk of death, extreme physical pain, protracted and obvious disfigurement. And I have to tell you, I'm not real happy with extreme physical pain because extreme is, again, one of those, it's subjective. There is no objective way to measure extreme, so I'm not a big fan of that particular, of B. And then there's D, protracted loss or impairment of the function of a bodily member, organ, or mental faculty. So serious bodily injury, it's a higher standard. You didn't just punch Johnny didn't just punch Joey. It's more than that, right? So again, those are the exceptions to an inability to remove a student before that MDR is held. So what if the parent doesn't agree with the outcome of that manifestation determination review? Then that parent has the opportunity to request a hearing to dispute the determination, and that's called a due process hearing. And so you can dispute not just the outcome of that MDR, but you can also dispute whether or not there is an exception. Right? Can my child be removed for 45 days? And in most instances, that is going to be that serious bodily injury. Or I could also see where, as it relates to the controlled substance, that, a parent might be able to argue that their student had it for a reason, and that student might defend that, no, I wasn't attempting to sell. Those are even on that weapon, again, just going back to a student who does not have a true weapon and being able to then challenge that 45-day removal. And so, but also understand that the LEA, the school division, they can also appeal. So let's say you challenge the that 45-day removal for one of the big three, right? And for whatever reason, it is upheld by a due process officer. Then the school, they can appeal that. And you know what? I'm getting ahead of myself, so let's move on. So what happens to a child during a due process hearing when that parent is challenging their removal? Well, stay put is the provision that will then kick in. So when there is an appeal, your child is able to remain in their current educational placement until the conclusion of that due process hearing. And then if there is, and so if that due process hearing, if the hearing officer determines that your child is to be removed to an alternative placement, then that alternative placement becomes the stay put location during that second, if you appeal all the way to the circuit court. Let's see. So circuit court. So again, you have gone through your manifestation determination review hearing. The school division has determined that it is not a manifestation of your child's disability. You have appealed and you have now gone through due process, and that hearing officer has also decided that it is not a manifestation of your child's disability. You now have the ability to appeal one more time to circuit court. And so I would advise parents that would appeal to circuit court, do not represent yourself. Do not go ex parte. Don't go before the circuit court attempting to represent yourself. The school division will have their attorney. Matter of fact, the school division has their attorney even during a due process hearing. These are hearings that they're challenging, and there is a lot of work that goes into preparing for them, even for attorneys. And so I encourage parents, if you are going to go to due process and then appeal even then to the circuit court, I encourage you, I implore you, have representation in those instances. So you absolutely can appeal. And that appeal is, again, going to be heard in the circuit court in the jurisdiction where the school division is located. Okay. So let's go through those steps once again. It starts with a behavior. There's a behavior that your child has exhibited that has caused the school division to now decide they would like to remove your child for more than 10 days, or there has been a pattern of behavior or a pattern of removals that the school division is attempting now to remove your child from their educational placement for more than 10 days or cumulatively more than 10 days. Now, you, the parent, the school division has got to give you notice of this intent to remove your child, and they must provide you with notice that there is going to be a manifestation determination review. I encourage you reach out to the school as soon as you get the notification so that you are able to provide the dates that will work for you. You don't want to allow the school division to just decide, be a part of that determining process. You want it to happen as quickly as possible, but you also want to make sure that you have time to prepare and that you have time that you are able to take away from work, or that you don't have conflicting obligations at a time that the school division may select without you. Now, you, the parent, your student, relevant members of the IEP team, and anyone else who is able to provide relevant information, anyone with special expertise about your student. Those are the folks that need to be in attendance at that manifestation determination review hearing. It is so important to bring everyone who can speak to what your child's abilities are, who can speak to what your child's triggers potentially may be, who can speak to what causes or how to de-escalate behaviors. And then there is going to be the hearing, and then there's going to be a determination made. It's either going to be, yes, it was a manifestation of my child's disability. Yes, it was substantially related to my child's disability. Yes, the school division, they failed to appropriately implement my child's IEP, or they failed to appropriately put into place the supports that would keep my child from having this behavior, from having this behavioral challenge. Or no, it was not a manifestation. No to all of those. It can't be no to just one. It's got to be no to all. And then there's either going to be placement maintained or a placement change. And in that placement change, again, those special considerations, if it's one of the big three, weapons, drugs, or serious bodily injury, there could be a 45-day change of placement and an MDR hearing. You see, that 45-day placement, that's just for safety of the student, the school, and all of the other folks in the school. But that manifestation determination review was going to determine whether or not your child gets to come back to their current educational placement, or whether the school division is able to make this transition at least for as long as they intended to suspend or to remove your child from their regular educational placement. So if your child is removed for 45 days and they are considering expulsion, you are then facing, okay, the 45 days plus an expulsion. Or if it is that 45 days plus another 30 days. So you're then looking at 75 days. So understand that if there is a 45-day change of placement, that MDR is still going to determine what happens at the end of that. And with that recommendation for whatever that child's placement will be after that 45 days. And remember that you have the right to appeal. You can appeal not just the MDR, you can appeal a 45-day removal as well. And what happens to your child in the pendence of your appeals, they are in stay put. If at the end of a due process hearing, however, it is determined that your child's placement must change, then that changed placement becomes the new stay put placement. And then finally, after all remedies have been exhausted, a final placement decision is going to be made. So you must be prepared, and I am excited to talk about this more in depth tomorrow, preparing for that MDR. No one should take lightly when their child is being considered for an exclusion from their regular educational environment long term. And I know that no one does take it lightly, but the preparation is key. Preparation, preparation, preparation. So who should you call if you need help? There's the Virginia Department of Education. There's the Dispute Resolution Department of the Virginia Department of Education. There is also the U.S. Department of Education, and more specifically, OCR, the Office of Civil Rights, where you are able to get help if you feel as if you are not being appropriately heard. And then I would also lift up again the Disability Law Center of Virginia. They have exceptional experts who are able to help you figure out exactly what the best course of action is as you prepare to support your child. So with that, I would love to entertain any questions that anyone may have.